Hello, everybody, and welcome to the Online Litigator, a place where our goal is getting better at practicing law on Zoom. Today, we're talking about the status of remote hearings in Pennsylvania state courts. Joining me to help make sense of the situation is Dan Cummins. Dan is the managing partner of Cummins Law in Clarks Summit, PA, and has over 25 years of civil litigation and insurance defense experience. He also runs Cummins Mediation Services, where his practice includes online mediations. Finally, he is the author of the wildly popular blog titled Tort Talk, which I know many of us read more religiously than the New York Times. Dan, thank you for joining us.
Thank you, Matt, for having me on the Online Litigator. Appreciate the opportunity to talk about the future of Zoom litigation in Pennsylvania.
Now, before we begin, set the stage for me here, because remote court means different things to different people in different parts of the country. What proceedings exactly are we talking about here today in Pennsylvania?
Sure. I want to emphasize at the outset that what we're not talking about is jury trials by way of Zoom or Skype or other ACT methods. No one that I have talked to is in favor of that, whether it be a judge or a civil litigator. So we're not talking about jury trials. What we are talking about and what we are seeing here in Pennsylvania is that lesser proceedings such as status conferences, scheduling conferences, obviously depositions and civil litigation matters, all of those are starting to become the norm in terms of using Zoom for those type of proceedings.
So you mentioned that term ACT. What is your understanding of the state of the law at the Pennsylvania state court level with respect to remote court, and what does ACT mean in Pennsylvania?
Sure. And ACT stands for Advanced Communications Technology. And here in Pennsylvania, we all, not only just in Pennsylvania, but across the world, went through the COVID pandemic. And prior to that, the use of Zoom was unheard of, essentially, in the court system. Perhaps you had phone conferences with the court or with opposing counsel, but no one thought to use Zoom. Then comes the pandemic, shuts down the court systems. In the beginning, most lawyers and judges thought that perhaps this might be a 2-week or a month-long stoppage of work. But when it became apparent that the pandemic was going to last much longer than that, litigators and judges began to look for other avenues to keep the wheels of justice turning. And so, fortunately, there was a platform called Zoom, a little known platform called Zoom at that point. And everybody at first reluctantly began to try to learn how to use that. And it became a way to keep the cases moving forward. In terms of the status of the statewide rule in Pennsylvania, there is no statewide rule in Pennsylvania for the use of advanced communication technology. I know that back in June of 2021, which was after the end of the pandemic, there was a convention of the state trial judges here in Pennsylvania. And as part of that proceeding, there was a task force created called the Remote Proceedings Task Force. And that was headed by Judge Terrence Nealon of the Lackawanna County Court of Common Pleas. And it consisted of about 10 judges from around the Commonwealth of Pennsylvania, all trial court level judges. And they wrote up a report that recommended the continued use of Zoom and other forms of ACT in the court system, but again, not for jury trials, rather for lesser proceedings like that. And about a year after that, in June of 2022, the Pennsylvania Supreme Court began to draw back their COVID orders in which they imposed upon the trial court to use Zoom to keep the wheels of justice turning. But with the COVID pandemic going in our rearview mirrors, Supreme Court began to draw back on that. And so that left us without any statewide rules or local rules. According to newspaper articles in the Pennsylvania Law Weekly, in that summer of June of 2022, there were several proposed rules for continued use of remote proceedings at the Pennsylvania Supreme Court level. There was the Civil Rules Committee, the Orphans Court Rules Committee, Family Law Rules Committee, and several other committees, but not a Criminal Court Rules Committee. And all of those committees were proposing the formulation and adoption of statewide rules to guide attorneys on how the continued use of ACT would proceed in the court system. Unfortunately, by September of 2022, all of those committee efforts at the Supreme Court level, all of those proposed rules were discontinued by the Pennsylvania Supreme Court. There's no public comment from the Supreme Court as to why they were making that unfortunate move, in my opinion. I thought it would have been a great thing to have one set of statewide civil rules or family law rules or orphan court rules on how we would do this going forward. The closest to any comment from the Supreme Court as to why they were discontinuing that movement was that the court felt that it was important for the bar and the bench to first get back to the pre-pandemic levels of live and in-person functioning in the court system before they would enact rules to allow for the continued use of Zoom. And so that is when the movement died at the state level, leaving it to the trial court judges to consider whether or not to enact local rules for the continued use of ACT.
Wow, that was a very, very thorough answer. Thank you. It's impressive, that mastery of the facts and that timeline that you have. Thanks very much. And, I just, as you were talking, I thought you're mentioning Zoom, and I talk about Zoom Court. ACT, of course, includes other platforms in addition to Zoom. I know in Allegheny County here, we use Microsoft Teams, but as we use those terms interchangeably, right? ACT, Zoom Court. Okay, so the lack of a statewide rule at this point, what has Lackawanna County done in response to that absence of a statewide rule? That's
where I practice, Lackawanna County, which is in the northeastern part of the state. The court sits in Scranton, Pennsylvania. And Lackawanna County, through the efforts of Judge Terrence Nealon, who, as I mentioned, was the leader or the chair of the Remote Proceedings Task Force at the Pennsylvania Convention of State Trial Judges back in June of 2021. He's a civil litigation judge here in Lackawanna County. And in addition to helping to write up that detailed report promoting the continued use of ACT across Pennsylvania, he also drafted the local rule that we use here in Lackawanna County. And that was initially began to come into play, I would say, in the spring of 2022. And the process was that Judge Nealon essentially wrote that rule based on the findings of that task force. And he wrote the rule in a manner that it would be within the confines of what the Pennsylvania Supreme Court had already been considering through its own Civil Rules Committee, so that he wouldn't violate that, and so that the local rule would have a better chance of being approved by the Supreme Court, which was part of the process. And so Judge Nealon drafted that rule and submitted it to the Lackawanna County Civil Rules Committee, of which I was a member. And that committee created a subcommittee of 3 lawyers to take a closer look at that proposed rule, which is Lackawanna County Rule 175. Take a closer look at that rule, propose some edits, and then bring it back to the larger committee. I was a member of that subcommittee, which was tasked to review and edit or suggest edits to that rule created by Judge Terrence Nealon. The 2 other members of that committee were Paul Oben of the Music, Pennsylvania Law Office of Dougherty, Leventhal, and Price. And the other one was Jack McGrath, who's a member of Marshall Dennehy in their music office. And after we worked with Judge Nealon to fine tune the language of that rule, took it back to the committee. The committee approved it. And then Judge Nealon did what was required, which was to submit the proposed local rule to the office, the administrative office of Pennsylvania courts and or the Pennsylvania Supreme Court. And then it seemed to go into a black hole at that point. And we didn't hear anything for almost up to a year. And then we heard in September of 2022 that the Pennsylvania Supreme Court was discontinuing the effort on a statewide level, which caused us some concern as to whether or not the local rule would be allowed. But thereafter, Judge Nealon inquired of the AOPC, the Administrative Office of Pennsylvania Courts. And fortunately, shortly thereafter, I think because the local rule was within the confines of what was being considered by the Pennsylvania Supreme Court, Judge Nealon got word that the Supreme Court was allowing that local rule to go forward. And so immediately thereafter, Judge Nealon submitted that proposed local rule to the president judge of Lackawanna County, which was and still is Judge Trish Corbett. And she promptly signed a court order approving the local rule on January 12, 2023, earlier this year. And so that rule was then approved, and it became effective after 30 days after it was published in the Pennsylvania Bulletin. And so by now, that rule is effective here in Lackawanna County, making Lackawanna County the first county in the Commonwealth of Pennsylvania, to my understanding, to enact a local rule about the continued use of ACT in the court system.
And why do you think that is, Dan? Why do you think that Lackawanna County stands alone in that regard?
I think first and foremost is that Judge Terrence Nealon is innovative. He's a well-known jurist who writes numerous opinions and helps to craft the law of Pennsylvania, in my opinion, from a trial court level. So he's innovative, he's forward-looking, and he saw an opportunity here to help codify what we had been doing during COVID, so that lawyers coming into Lackawanna County could know in writing through the local rule what to expect in terms of Zoom proceedings. And I think there's a general reluctance in the public trying to teach old dogs new tricks with Zoom. There's a reluctance. There's the fear of a slippery slope that are they going to someday turn jury trials into remote proceedings? And there's never been any sense of that. Although there's a fear of that, there's no realistic sense that the movement is ever to turn a jury trial into a remote proceeding. The movement has always been to utilize Zoom for lesser proceedings to make the practice of law more efficient and to save lawyers time and to save litigants money.
Okay, so what are the highlights of the Lackawanna County Local Rule?
The rule is both flexible and discretionary. For example, although if a court orders that some minor proceeding is to be by way of Zoom, under the rule, there's a flexibility such that one of the litigants could request the opposite. For some reason, if they want it to be live and in person, they can submit that request, and that would certainly be considered by the court. And I think it would be granted. I think the court will err on the side of what the litigants want. And the same thing vice versa if it's set up for a live proceeding. And if an attorney can tell the judge that the parties are in agreement that this is a relatively simple matter that can be completed by Zoom, I would think the judges of Lackawanna County would go along with that as well. But the rule itself, to address the fears out there of Zoom taking over the practice of law, the rule itself in Local Rule 175 subsection B specifically says that ACT shall not be used for jury trials. And not only is it prohibited for jury trials, it's also not to be used in any hearing or argument where the party might have to introduce evidence, some piece of paper or a photo or an item, anything involving the introduction of an exhibit. The rule says that ACT should not be used for those type of proceedings. In Rule 175C outlined the different types of proceedings that it might normally be considered compatible with the use of Zoom, such as an initial scheduling conference, where parties come to the court and just get scheduling deadlines, an initial conference to discuss a trial date, also for oral arguments on contested motions, certainly court presentations on uncontested motions. Also, most of the discovery disputes will be by way of Zoom proceedings. And this furthers the efficiency of the court system, saves the litigants time and money. And as an example of that, I was just frustrated just earlier this week. I'm up in Scranton, Pennsylvania. I had a case down in Redding, Berks County, 2 hours and 15 minutes away. And I was required by a judge in that county to come for a status conference, the first conference in the court system. We spent 10 to 15 minutes together. The judge did try to turn that into somewhat of a settlement conference to make it a little more substantive. But even that could have been performed by Zoom. And so I spent 4.5 hours on the road earlier this week for a 10 to 15 minute conference.
Ah, that hurts. That hurts.
Yes.
I mean, it really does.
And to top it off, it was a flat fee file. I'm an insurance defense attorney. We get paid by the hour normally, but more and more insurance companies are switching to flat fee files. And so no money was made that day on the defense side or even the plaintiff side because the case did not settle. It's just an example of the inefficiency of the old days. And hopefully we can do away with that more and more with the use of Zoom, make the practice of law more efficient and more economical for everybody involved. That being said, there are some larger defense firms across the Commonwealth of Pennsylvania, more so in the big cities, who are pushing against Zoom and ACT because it does take away from them that windshield time, that time on the road that in some cases they can bill for. Most of my clients, insurance company clients, don't allow for travel time anymore unless it's more than 75 miles round trip. And even where they do allow it, it's only at half the hourly rate or half the time. So there's limitations on it. But when you have a big law firm and you have much more overhead, every bit of billable time counts more. I'm a small firm, so that does not impact me as much. I'd rather be more efficient sitting at my desk, do a 10-minute conference on Zoom and move on to something else, especially in a case where I cannot bill for my time on the road. So that's, you asked me before about why it's not spreading quicker. In addition to the reluctance or the fears brought on by Zoom, there's also a loss of billable time, a substantial loss of billable time for some big city, big firm on the defense side.
From somebody who practices on the plaintiff side, it's interesting to hear that perspective on the impact that the insurance companies play on all this, because it's not something I really have firsthand exposure to.
On the defense side, it's all about the billable hours, tracking your time. And if you can get additional time to bill on a file by traveling from Scranton to Redding, some might like that. I myself don't. I'd rather, even if I was earning compensation on that and it wasn't a flat fee, I still view it as inefficient and prevented me from working on my other files and keeping the whole practice moving in a more expeditious fashion. So there's two schools of thoughts on that.
It sounds like the Lackawanna County Local Rule tries to balance those two schools of thought. Do you think that it is a viable model for other counties in Pennsylvania to follow?
I do. First and foremost, because it was written by Judge Terrence Nealon, who was a member of that remote proceeding task force at the Convention of State Trial Judges. And so it's backed not only by Judge Nealon, but by those judges at that conference who came up with these ideas, discussed them, and worked through them, the pros and cons. And even they did not advocate for jury trials by Zoom. It's much more practical, and it's geared towards taking those simple proceedings where you don't need the attorneys to travel to the court, and that could be dealt with over Zoom. So the focus of this rule of Lackawanna County is on practicality, and the emphasis in the rule also is a flexibility of if it's set up for one way, whether it be live and in person or by Zoom, there's the flexibility if the parties so desire to switch it to the other avenue of proceeding. And so it's a straightforward rule. It's simply worded. It's tightly worded. And we do believe it will serve as a model for other county courts to at least consider when they hopefully also go to draw up their own local rules to govern the continued use of ACT in their counties. But again, the hope remains that the Pennsylvania Supreme Court will revisit the issue. And in the articles about that, they do suggest that the Supreme Court is not saying never to a statewide local rule. They're just saying we're not going to do it now. We want to get back to a normal practice of law first, and then we will reconsider whether or not to do a statewide rule of civil procedure. And so the hope is that Lackawanna County, being the first county to do this, the hope is that their local rule will serve as a model for other county courts, and hopefully a momentum will begin again, such that the Pennsylvania Supreme Court will make the wise decision to revisit the issue and create a statewide local rule so that attorneys are not, as they are in many instances, required to look at each county's local rules on very common issues across the state to figure out how that particular county does ACT in their court. And hopefully we can get to a uniform system like perhaps New Jersey uses, where they have one set of statewide rules of court, and they're not burdened by local county rules or county customs, which can make the practice of law somewhat more burdensome for lawyers.
I want to be valuable or mindful of your time here. I want to ask you just one more question. What's the response been by the local bench and bar in Lackawanna County? If we're trying to entice other jurisdictions to follow this lead here, how's it gone in Lackawanna County?
Great. There's been an overwhelming positive response to it. The lawyers like the fact that they could hop on their laptops, participate in a quick, simple meeting with the court, whether it be on a discovery motion, a quick argument on a motion for summary judgment, or simply touching base with the court on a status conference to get scheduling deadlines and perhaps a trial date. Simple proceedings like that. The judges seem to like it, find it more efficient. Rather than spending an hour driving to the court, parking your car, walking to the courthouse, going up the elevator, doing a 10-minute conference with the court, and doing the same process to get back to your office, simply hop on your computer and get it done. Also want to emphasize, they're not advocating Zoom for the settlement conferences. The judges still have us come in for that. There's something about having people in person is more productive in terms of settlement talks, but the judges are considerate of the fact that most insurance company representatives are from faraway areas, some of them even out of state. And so they might have the attorneys come and the plaintiff come to the courthouse, but they're open to having their claims representative by Zoom, which is even more powerful, I think, than just having the claims rep on the phone. And so I think we're seeing more cases getting settled through that process as well. So the response has been overwhelming. Hasn't been any negativity that I have heard, other than those some bigger defense firms who lament that they can't drive up from Philadelphia for their 10-minute conference and get all of that billable time. But the loss of that billable time, I do not believe, is a valid reason not to keep moving forward with the use of ACT in the court system. So
that's great.
Yeah.
It sounds like a real success story. You haven't had anybody show up as a lawyer cat, have you?
Not yet.
All right,
No,
good.
That's a good thing. Yes.
All right. Well, Dan Cummins, thank you so much for joining us.
And thank you for having me. I appreciate the opportunity, and I appreciate the great work that your law firm, Probanik does out in Pittsburgh, not only in this arena, but for your clients.
Well, thanks very much.